Baada ya gavana wa kaunti ya Meru Kawira kukata rufaa katika Mahakama Kuu kufuatia uamuzi wa seneti wa kumbandua mamlakani. Sasa ni pigo kwa gavana huyu baada ya Mahakama Kuu ya Milimani kukubaliana na uamuzi wa seneti kwa gavana Kawira alibanduliwa mamlakani kwa misingi ya sheria.
This court is satisfied that the charges laid before the Senate and which were considered by the chamber in favor of impeachment were of a nature that meets the requirements of Article 181, Clause 1 of the Constitution, and the petitioner has not shown that the Senate's analysis of the applicable law and evidence was so profoundly incorrect that no reasonable quasi-judicial body properly applying its mind to the law and the facts would have arrived at that conclusion and thus warranting interference by this court.
Mwangaza alilalamika kuwa hatua zifaazo hazikuwa zimefuatwa katika kung'olewa kwake mamlakani, jaji wa mahakama hii Bahati Mwamuye akitupilia mbali lalama kuwa gavana huyu hakuwa amepewa fursa kujitetea.
Another aspect of the petitioner's argument is that she was only given 2 minutes to make a personal statement at the conclusion of the proceedings and that she did not get the chance to deliver it. However, the court's review of the Hansard and video recordings indicates that the Speaker of the Senate granted her the opportunity to speak. The uncertainty regarding whether she remained silent by choice or whether there was a technical issue with her microphone does not alter the fact that she was given the opportunity to address the Senate. Moreover, her legal counsel did not raise any objections during the proceedings, either regarding the time allocation or any technical difficulties.
Na kutokana na madai kuwa kubanduliwa kwa gavana Mwangaza kulichangiwa sana na ubaguzi wa kijinsia, mahakama imebaini kuwa walalamishi au kudhibitisha madai yale.
The petitioner and the second interested party have not particularized this complaint with specific reference to the Senate's proceedings or shown an aspect or element of the proceedings before the Senate that show gender bias against the petitioner. Perhaps this is because, while we have a wider problem with gender bias, the Senate conducted its proceedings strictly without any form of gender bias against the petitioner.
Kulingana na Jaji Bahati, mahakama haiwezi badilisha uamuzi wa bunge, ila wajibu wake mkuu ni kubaini kuwa ikiwa mchakato ufaao ulifuatwa.
The High Court is not required to assess whether the Senate made the right decision, but should only determine whether the procedure followed was fair and constitutional. A proper reading of these decisions in light of the Constitution requires that this court can only engage in a merit review of the decision of the Senate if the decision of the Senate on the applicable law and/or evidence was so profoundly incorrect that no reasonable quasi-judicial body properly applying its mind to the law and the facts would have arrived at that conclusion.
Kawira anapotimuliwa, kwa wengine ni shangwe na nderemo, wakisema kuwa wamekamilisha safari walioanza.
Thank you, Lord. Asante Bwana.
Isaac Musyoka, Undugu TV.